Yeah. Rude awakening. Like, ooh.
Okay, can you hear me? Can you hear me now? Okay, good. Okay, so would you like to begin, or would you like us to begin, or should we wait for the others? We have about, how many participants do we have? We have about 13 students. Yeah, we will begin. Okay, let's start. I'm just gonna close the windows. Okay. Hold on, give me a second. Okay, when I look at the signal of my internet, it doesn't look good, but hopefully you can hear me well. So, hold on, let's see. So let's start. I'm gonna do the share screen now. Okay, so in terms of learning outcomes, what we hope to do tonight would be to, after the session, you should be able to identify legal issues. So that's what we hope to do, to help you have some practice in terms of identifying the legal issues, and in particular, identifying the legal issues in the legal memorandum assessment. And then, as a result of tonight's session, you should then be able to apply the IRAC format to the legal memorandum assessment. Now, I remember there was actually a comment made by one of the students in one of the discussion fora, which I did not get the chance to respond to, mainly because my computer then malfunctioned, and I had to bring it to the Brisbane campus ITD to get it fixed, and they actually had to reformat the hard drive. But if I recall, the point that she was raising, which is quite valid, is that she was getting confused on how to identify the legal issues. Now, the thing I'd like to point out is that somehow it's not really the task of constitutional law or any specific law subject for that matter to be talking about the IRAC format. It is somehow just assumed that students will learn it. And so, but assuming that you did not go through the process of trying to learn how to use the IRAC format, so I'm gonna kind of discuss it tonight. So that's what we hope to do. Now, before we do that though, would there be anything that you may want to discuss, or if there's a question that you may want to raise before we start and talk about the legal memorandum in the context of the IRAC format? Anything you'd like to raise? Questions? Are we all?
I have a question, Amanda.
Yes. Who would this be?
It's Margie.
Maggie. Yes, go ahead, Maggie.
Just quickly, and I know this is not to do with the legal memorandum tonight, but when we do the tutorial session each Monday with regards to the discussion questions, I really think that a lot of people are getting really confused and a bit lost with how we're approaching that. And I think it would be more beneficial if you just asked for some comments relating to the discussion, but then you actually went into the discussion question and talked about it and went through how to answer that particular question and do that, because we're not sort of really, well, I don't know, I get the impression that other people feel the same, but we're not really learning anything from it. Like, I still come away really confused and I don't know what the answer to the discussion question is. And to me, that's the component that we should be working on to learn. So I'm not sure how everyone else feels about that, but I just thought I'd ask if maybe we could just approach that a little bit differently going forward, and just maybe you say, okay, who wants to offer some comments? Just take a few comments, but then you go into it and explain it to us, because I'm not getting it, I'm afraid.
So instead of, if I understand you correctly, instead of getting the students to come up with their own answer, I'll get a few comments and then I'll give the answer. Is that it? Discuss the answer.
Yeah, not so much just give the answer, but explain the answer.
Okay.
Like, we need to know the answer, but we need to know the concept. Thank you, Catherine. The concept of it.
And it wasn't done quite well the previous weeks, I imagine, as you pointed out.
No, I don't believe so. I think we're kind of going off into a tangent and we're discussing too many other things, and people are just getting really confused.
Okay.
And it's not really like, we're not the experts, you are, so we need you to teach us. Okay.
So because sometimes what has happened is that there are some concepts which are relevant to the discussion question, and they end up explaining it as well, although it's not actually a topic that ought to be discussed in the discussion question. So would you rather that I limit the discussion specifically to whatever ought to be discussed in the discussion question without pursuing?
Yeah, I feel so. I think the students would benefit from that more.
Okay, we can try that approach. Yeah, thank you. So thank you for that feedback. So we will do that on Monday. And so from what I gather from you, I'll take a couple of comments and suggestions, answers from the students, and then provide the answer and explain why the answer is that way. And would it also mean that I will not have to go through the process of trying to identify trying to get the students to identify the legal issues, more of just presenting the legal, what I think the legal issue ought to be, then, applying the rules and so on? Would you
yes.
want it to be that way, meaning more directive?
Yeah. Yes, I think that would be much better.
Okay, yeah, because that's the thing. There are various approaches to kind of to teaching a subject. One is I look at it from a background of having kind of studied teaching and learning as well. And one approach is that you kind of look at the lecturer as the sage on the stage, as the person who's the expert, and that's when it's more of didactic in the sense that whatever he has in his mind, he tries to pass on to the students. That's one approach. Okay. The other approach, though, and that kind of style of learning actually involves what is known as passive learning. That's the traditional approach, because it's more teacher-centered. And that's what the lecture usually does. When you have a lecture, it's really didactic, it's teacher-centered. This is what I know, and I'm passing the information on to you. The other approach, though, is what is known as kind of more student-centered, and that makes an assumption that there is something in the students' minds that they can actually contribute to the community of learners. So instead of all the knowledge being in the lecturer, there's a lot of knowledge actually out there in the students, and the role of the lecturer is to take that knowledge out and bring it out into the open. And so there's that community of learning that goes on. The assumption is it becomes more active in the sense that students actually participate, students actually engage, and they get valued. Now the problem there, the danger, that poses a danger in the sense that for some students, and I can totally understand that is an unfamiliar process, because it is as if, it's like, who's the expert now? It's like, we're trying to hear from so many people. Okay, but actually there is literature in that which strongly suggests that is actually a good approach. But if you're suggesting that, we take it the usual way, where I just say, this is, what it is, and, you just listen to me, that's possible. But my only concern in that type of approach is that it is no different from a traditional lecture, where I am the sage on the stage, and I'm the font of knowledge, and and I'm just passing on the information too. It's just so passive, and which is why what I try to do is try to get students to really engage, really get to force them to think. So instead of students listening to what I say, I want students to think, and in the process of thinking, of course, you can end up becoming confused. And the point being that on the one hand, you can have a path where the teacher tells you this is the direction of what the knowledge ought to be, and this is what the answer should be. That's one approach. But on the other hand, there is an approach where, with so many ideas coming from various students, at some point you synthesize so much knowledge. So there's that tension. I wouldn't go for the traditional one, which is the didactic approach. I kind of believe in the community of learning approach. Now, hold on, let me just see. I'm just looking at Catherine here. Then with us. Catherine, would you mind just, using your mic for that? Catherine Wood.
Hi there, sorry if it's loud in the background here. Basically, I don't know whether other students agree. I think Cheryl said that she does, and perhaps what Margie was trying to say was, when we first start a session, we start looking at the questions, students can give their thoughts and perhaps a bit of a discussion, which gives the second form of teaching that you were just discussing there. But also, I guess, at the end of that, I think some direction, just as to the main concepts and the main ideas, and how that actually applies to the question would actually help in terms of, for example, the assignment as is now, as to how to find the main legal concepts, where you find the main legal concepts, and how they're actually applied to the question.
Okay, so that's good. So at least I'm explaining to you now, because I've got a background kind of in teaching and learning. In fact, before I joined the law discipline, I was actually part of the teaching and learning service of CQ Uni. So my job was actually to assist the academics to improve their teaching practices. So I came in as a lecturer for academic professional development. And I kind of use these ideas mainly, especially in the context of online learning, because some of us, perhaps, especially me, when I was younger, the approach had always been, and I wonder for the others as well, the approach has always been, and it's true mainly in high school as well, where you've got the teacher, just telling you what knowledge is, and it's meant to just go into your mind. But, that's really passive learning, and I'm hoping, the active learning part. But to a lot of students, indeed, the literature says it can get confusing, and it can make them very uncomfortable. But so I think what we can do is looking at Oh, okay. So there's a viewpoint from Patrick. He says he agrees. Now, so what I'm going to do, I think, on the one hand, I would like to go. I don't want to, as I pointed out twice in the two tutorial sessions we had, the first and the second one. I pointed out that the tutorial session is not going to be another lecture. Okay, I made that very clear. I've got the lecture videos for that. I've got the lecture notes for that, which I personally prepared. That's me talking. Now, this is now your opportunity to talk during the tutorial session, and I'd like everyone to engage, and which is why I'm trying to get the engagement in the chat box as well as in the using the microphone. But as I said, that can get quite uncomfortable for some. So what I would then do, is we will do a mix of both. I'll get students to share their ideas, and then provide the direction on what the answer ought to be. But actually, I had always thought that I was kind of succeeding in the second part where I would then give the answer, because I think at the end of every discussion question, I did provide the answer. I think the only problem may have been that I tended to digress in the sense that there were some relevant concepts that were raised in some questions, and then I would then explain what those concepts are. And perhaps some students found that confusing. So what I will then do is, as suggested, a mixture of both. I will privilege, therefore, meaning value the knowledge coming from students, so let them participate, let you engage, and then I'll give my suggested answers to provide more direction. And I will avoid trying to explain concepts which are not apt to be discussed in that particular session. Meaning, if they're apt to be discussed, let's say in week 8, then I will just say I'll discuss that in week 8. So in that case, you won't be dealing with too many legal principles and concepts. Would that be okay? How does that sound? Sounds good. Now, for the others, can you just turn off your microphones for now? Because I think we're getting a lot of background noise. I wonder if it's Amanda. If your mic might be on, Amanda. You might.
Sorry about that.
Yeah, thank you. Okay, good. Now, any other comments before we continue? Any other questions, concerns, suggestions?
Yes, Manjo, I have a quick question.
Yeah, go ahead, Jessica.
I know it's been a little while, and I know you've had some computer issues, but would it be possible to start getting some of the discussion answers in written form?
Yes.
Just sometimes things get a bit lost in chat, so to have that written sometimes is a little bit easier.
Yes, I'll try to get that done over the weekend. The problem was after my computer broke down on Friday, and I brought it to the Brisbane campus to get it fixed, they actually had to reformat my hard drive. Unfortunately, I had the Dropbox folder, and then a lot of files on my desktop. The problem with Dropbox is that it doesn't save the ones on the desktop. They're in the Dropbox folder. But because there are so many folders in the Dropbox folder, I've always put my active files in the desktop, and I kind of lost a number of those. So I'm going to kind of retrieve them, find a way to redo everything again. But I should be able to start posting the answers over the weekend, including the lecture videos. I think week 5 video, and then week 6 as well. Yeah, but the other point is about backing up. I just I'm actually moving away from Dropbox now. I'm actually using I think it's called Just Cloud, because Just Cloud copies everything in your computer. It doesn't have to be in a specific folder like Dropbox does it. And so it does it in the background. So you don't have to think about, saving it in the Dropbox folder, which can be quite an inconvenient thing to do. But yeah, that's lesson learned. Yeah, but it's not the end of the world for me because I didn't really lose everything. It was just some of the files that I had. Okay, anything else you'd like to ask before we continue? None? How many students do we have so far? How many participants are there? Just checking. Oh, we've got 20 students, 21 participants. Okay, that's good. So let's begin. Now, what I'd like to do before we start talking about the various proposals, and I'm not sure if we'll be able to cover all of them. The important thing for me in having this session is for you to learn how to identify legal issues. Because if you have that skill, if you learn that skill and learn how to apply the IRAC format, meaning develop the knowledge and the skill in terms of how to use it, then you can use it in any legal subject that you come across. And that's what I'm focusing on. So it's not so much you being able to identify the legal issues tonight in relation to the legal memorandum, which we will actually attempt to do, but it's more you being able to develop the skill to be able to identify legal issues and apply the IRAC format, particularly to the legal memorandum assessment, but to any case problem, to any legal problem for that matter. So that's what we hope to do. Now, would there be any other questions before we proceed? None so far. Now, what I'm going to do in the first instance, before we go to the legal memorandum itself, would be to talk about the IRAC format. Okay. The one thing that I like about the IRAC format, and IRAC actually really means, let's see if I could type here, being able to identify the legal issues, and then being able to state the rules or legal principles, and then apply the rules or legal principles to the legal issues, and then arrive at a conclusion. So arrive at a conclusion, or state your conclusion, or state a conclusion. Hold on. Hold on, give me a second. Hey, Kevin, I've got a class. Call me later. I've got a class. Okay. Okay. So that's the IRAC format. So that's IRAC because that's issues, rules, and then the application part, and then the conclusion part. So that's what it means. That's why it's called the IRAC format. Has everyone come across the IRAC format? Actually, it seems to be quite standard in law schools. In fact, if you search it up on the internet and you type IRAC, there are lots of resources in the internet coming from law schools talking about the IRAC format. Oh, so that's it. Yeah, so it's discussing intro to law. So that's what I'm pointing out. So there is an introduction to law. It is not for me actually to discuss the IRAC format. That's meant to be done by something else. I'm discussing constitutional law, but at any rate, because that has been raised, we're doing that now in the context of the legal memorandum. Now, there is actually a beauty and a logic to the IRAC format. Put it this way. Let's say you went to a doctor, okay, because you felt sick. And mainly when you say you feel sick, you have a headache and you've got a fever. Okay, so you have a problem. Now, what then would the doctor do? The first thing that the doctor does is, does he just examine the problem that you've identified for him? Does he just say, oh, so you have a problem with a headache, I'll give you a paracetamol. You have a problem with a fever, I'll give you a paracetamol. Hold on, where is this now? I'm getting distracted with the chat box. So I'm not going to look at the chat box now because I find it distracting. I'm going to go back to the chat box in a short while. So, and yes, that's correct. You state your conclusion actually from the very start, but we're going to get into that because that's actually the format of how you come up with an answer to a case problem. So the job of the doctor in that instance will be to determine what exactly is the problem that this person is facing. Obviously, the symptom obviously would be the headache, and the symptom would be the fever. But there is an underlying problem. Okay, what is that underlying problem? If you put it in the context of law, for example, and somebody comes to you and says, in the course of my work, I ended up not returning money which I was supposed to return to my employer. Okay, so let's assume that you felt guilty because somehow you had about $250 which you were meant to return to your company, but you somehow pocketed it and used it for your own personal means. And then you go to the lawyer and say, What do I do? This is my problem. Now, the problem seems to be, if you look at it that way, the problem seems to be easy. The factual problem is, do I simply just return it? But actually, if he's a good lawyer, he will look at the possible legal issues. He could approach it from the viewpoint of law, from the viewpoint of criminal law. He can look at it from the viewpoint of contracts. He can look at it from the viewpoint of employment law. From the viewpoint of criminal law, he'll start asking questions like, did this person just commit theft? Or is it some kind of some other criminal offense? From the viewpoint of contracts, does he have a legal obligation to return the money to the employer? And if that money has to be returned, is that in the form of a loan or not? Would it incur interest? The other legal issue will be, if he were to return it, is it possible that he might end up losing his job? So in other words, there are a lot of legal issues from a simple problem. And as you will see later on, when we go through the proposals, there are a number of possible issues which you can look at, and some of you will say, oh, this involves about the right to citizenship, or this may involve a fundamental human right, those types of things. But then again, as you will see later on, when you say identify the legal issues, it is always in the context of what the assessment is seeking to find out, that you know and that you can apply. So that's the first. You have to identify the legal issues. Identifying the legal issue is crucial, because if what you do then is to say, oh, this is the law, without even identifying the legal issue, what value is there of you giving knowledge, of you telling me all the rules and the legal principles without making a connection to what my problem is? So it's like putting the cart before the horse. So, which is why even when we have and I'm digressing a bit, even when we have the final assessment later on, because it's open book, and this is kind of open book as well, the legal memorandum assessment, there's really little, I don't become impressed. It's not impressive if what you do is to state the legal principles and the rules. You're meant to know that. They're in your books, they're in your textbooks, you would know that. But your ability to identify the legal issues and then identify the rules or legal principles that are clearly relevant and related to those legal issues, that's something else. Being able to connect what the rules and legal principles you know to legal issues that you have identified, that brings you to a higher level of understanding, a higher level of knowledge. Okay? So going back to the metaphor, or not a metaphor, but to the example of a doctor dealing with a patient who complained about a headache and complained about high fever, he would then determine, what exactly is the underlying problem here, and then he will go back to his knowledge, his medical knowledge, and say, what do I know that is probably causing, the headaches and the dizziness? So he's now bringing the principles he knows, knowledge, to the problem that he has identified. In the same manner, in our case, having identified the legal issues, we then try to determine what rules or legal principles impact or affect the resolution or the answer to these legal issues. Okay? So you're only trying to draw the relevant rules or legal principles. So in our case, because we're dealing with constitutional law, we're mainly looking for constitutional law principles here. You shouldn't get into election law. You shouldn't get into criminal law. You shouldn't get into civil law, or civil procedure even, for that matter. Our focus is for you to be able to state the rules pertaining to constitutional law, or the legal principles pertaining to constitutional law that are related to the legal issues, so that by applying those rules and legal principles to the legal issues, you can then arrive at a conclusion that is well supported by evidence. And the evidence in this case would be the rules and the legal principles. So in other words, there is a logic to it. Correct? Because it will be difficult if you begin, when you come up with the format, you usually begin with a conclusion, as I'll explain later on, but your conclusion has to be supported by evidence, and that evidence are the rules and the legal principles. But before you can say that these are the rules or legal principles that support your conclusion, you have to make sure that those rules and legal principles are actually apt to the legal issues that you have identified. They've all got to be connected. Okay, so one must lead to the other. Okay, so the first stage to do is identify the legal issues, and that's what we will attempt to do. And we will do two approaches. Now, I'm not sure if I'm able to give you the, what I can, let me be clear about the limitations of this tutorial, okay? What I'm gonna, earlier I said that there were at least two approaches, and there's a, you know, it's a spectrum, and there's the middle approach. One approach is passive learning, the teacher tells everything. The other approach is a community of learners privilege and value the knowledge that students have, and find a way that their knowledge is brought into the pool of knowledge so that it enriches the minds of everybody else, okay? Now, let me be clear at this point, in this tutorial session, I am not in a position to identify the legal issues for you. I cannot do that. This is your problem. This is your task, okay? So let me be clear, for this tutorial session, what I'm going to do will be to go for the other approach, or the community of learners approach. It may end up making you confused. That's probably something I cannot help. But I am not here to tell you what the legal issues are, because that is something for you to determine. So are we clear about that? Neither can I tell you what the rules or legal principles are. In some way, I might end up, you know, telling you what they may be, but I cannot do that for you. That is your task. That is your job. You can do this after the session. You can arrive at, you know, once you've combined all the knowledge that you have, you may end up having a session after this. I could get it out of the session. This session could continue in Zoom for you to talk among each other. But certainly, I cannot give you the answers to the legal memorandum assessment. So that is a clear limitation for this tutorial session. Okay. Now, can you model how we would identify? We could. What I'm going to do is, from the facts, I will create another proposal, and then we can go through the IRAC format. And then I can be more directional in that case. So would that be fine? So what we will do is, we will begin first by going through the proposals, I think. And remember, to be clear, what is my approach? I'm using the community of learners approach here. I'm not going to be didactic. I'm not going to tell you what the legal issues are. I'm not going to tell you what the rules are. I'm not going to tell you how to apply the rules to the legal issues, and neither am I going to give you the conclusion. That is the entire purpose of the legal memorandum assessment. If I were to give you the answers, that will make a farce of everything that we're trying to do here, and I will get into trouble. So the most that I can do now is, as I said, to help you develop certain skills. You know, learn to identify the legal issues and properly apply the IRAC format to the legal memorandum assessment. But to do that, that will have to come from you. And then I'll come up with another conclusion. Somebody's calling me. Okay, never mind. It has to be it will have to come later. Now, at the same time, I'll develop another proposal from the facts that we have, and then we apply the IRAC format. So would you be happy with that? So we can proceed. So, what we're going to do now, just to put everything into context, before we start talking about the proposals have got to be contextualized in relation to the facts that we have. So I will ask a volunteer from among you to read the facts of the legal memorandum assessment. Hold on.
Can I just ask a question, Ranjay?
Sure, go ahead. And who might this be?
Tony or Anthony?
Tony, yes, go ahead, Tony.
With the legal memorandum,
yes,
right? When we write down our proposal, we got to say whether it's right or wrong, or you know, if half of it's right or half of it's wrong. What the conclusion we come up with is. And
Amanda, you're asked to mute your mic. Thank you.
Sorry.
The important thing is you should have a conclusion. Okay?
Yeah, no, I realize that. Yeah.
Okay, now your conclusion, I think the point you're raising is it possible to have two conclusions? Or are you required to come up with a single conclusion? Would that be it? Or is it possible to come up with a conditional conclusion? Meaning...
Conditional, conditional where you...
Can you pick up the phone again? Find out who it is, and then tell the person to call me back later. Okay. Tony, was I, correct?
Yeah, no. I just want to know, like, like you got 4 proposals there. You might say, well, 3 of them are valid and one's not, or half of one is and half of it's not.
Yes.
You know what I mean?
Oh, okay. Now,
as long as we can justify our answer, that's all right, isn't it?
okay, yeah, okay. Let me clarify something. Usually, if you're speaking of a law already, if there is any provision that is unconstitutional or invalid, it invalidates the entire law. Usually, okay? Unless there is a provision there which says that there is a saving clause, in the sense that on the assumption that this part is invalid, the rest are considered valid, that saving clause. We're not interested in you coming up with an overall conclusion and saying that, in general, the law is valid. Your approach should be to come up with your conclusions according to each proposal. It's per proposal. So you should come up with a conclusion as to each proposal. Okay, now, if the question is, what kind of conclusion could I arrive at? And is it possible for conclusions to differ according to assumptions that I may have? Now, the thing you have to notice, and I think I was asked this question for the legal memorandum assessment for administrative law. It is possible that there are certain facts which you feel should have been there but are not. In other words, if this fact had been there, this would have been my answer. If this fact had been there, this would have been my answer instead. In other words, because that fact is not there, or the facts seem to be vague, or the facts seem to be incomplete, then it's difficult for me to come up with a definitive conclusion. Are you following me so far? If you arrive at a position where you think the facts seem to be incomplete or seem to be vague, your job then is to make assumptions, okay? So then you will say, assuming that these are the facts, because the facts seem to be vague or the facts seem to be incomplete, assuming the incomplete fact to be this, then this is my conclusion. Or you can say that assuming that this fact should have been there, but it's missing, but if this fact had been there, I would have come up with a different answer and this would have been my answer. You're free to make those assumptions. And typically, in fact, when you deal with case problems, because cases are meant to be short, there are points where facts may actually be very vague or incomplete, but that's purposive. It's deliberate, okay? And that allows you, therefore, to determine, I need more information. It's like when you talk to a client and the client tells you something, you will then say, oops, sorry, I'm not in a position to provide you legal advice at this point because there are some missing facts here. You need to tell me more. You know what I mean? In this case, it's possible that when you go through the legal memorandum, there seem to be some missing facts. It is your job to try to present what those facts might be by making assumptions. Was that clear enough? Was that helpful?
No, that's all right. Yeah.
Okay, good. So, hold on. Somebody said if have is not, it is not right. What does that mean? From Michelle. Okay, Michelle. Would that mean that what if, let's say, out of the 4 proposals, 3 are valid and 1 is invalid? Is that the type of question?
Oh, no, Manjo. What I was saying was, Tony's question was, what if a part of the proposal was good, but the other part wasn't good? I was saying if half of it's not right, then none of it's right. The proposal has to fail. Yeah, you could say it that way. You could say it that way. But more than that, what's important for me, number 1, is that you know what the legal issue is. You've identified the legal issue correctly. 2, you're able to state what the rule really is, because actually, even if it's open books, from experience, a lot of students are unable to properly articulate what the law is. It's one thing to read the book, and obviously you cannot copy and paste, from the textbook. So you need to be able to put it in your own words as a warning, okay? You must be able to state the rules and legal principles in your own words, and then you apply. So I'm looking at those and then looking at the logical conclusion that you arrive at. So those have got to be there. Okay.
Manjo?
Yes?
I think more what Tony was getting at was, in like each specific proposal, for example, if you have more than one issue and you determine that maybe 2 of the issues are valid, however the 3rd issue is invalid, of course the whole proposal would be invalid. But are you wanting us to identify that this portion would be valid, however this further portion makes the whole proposal invalid?
Yeah, you need to be able to do that. If that's correct. If in a single proposal there actually happen to be 3 or 4 different legal issues, and obviously you end up with different conclusions for them, I need you to articulate a conclusion for each. I'm not interested in you saying that on the basis of 3 of these legal issues to be invalid and 1 being valid, the whole thing is invalid. It's not so much that. It's being able to identify each of the legal issues in a single proposal and having a clear conclusion at the end. So you will end up with multiple conclusions in relation to each of the legal issues. That's what I'm looking for. Because obviously, you know, it's an almost easy thing to be able to say whether the entire proposal is valid or not. Because if 1 is invalid, you can easily say that the entire proposal becomes invalid. So we're looking at you being able to identify each of the legal issues in a single proposal, and then arriving at a separate conclusion for each of those legal issues. Clear enough so far?
Can I just ask a question, Laurie here?
Yes.
I was just wondering, like, do we have to do like an IRAC for each proposal? Is that right? Or
sorry, I'm not hearing you well.
Do we have to do an IRAC for each proposal? Is that correct? Like, and each, oh, wait a minute. Like in each proposal, we have to, like, there's 4 proposals.
Yeah.
So we need to do an IRAC for proposal 1, proposal 2, proposal 3, proposal 4.
Absolutely, yes. Absolutely, yes. Absolutely, that's what you need to do. And in fact, more than that, if in a proposal there seem to be 2 or 3 key legal issues, you need to do the IRAC for each of those legal issues in a single proposal. Yeah, so that's Michelle's articulated it. You need to use IRAC for each separate issue within each separate proposal. That's the way it should be. Okay, clear enough? So we can proceed. Now I'm going to do a share screen again this time, and this time I'll have to ask someone to read the facts for us. Can I get a volunteer?
Yeah, I can read it. It's Patrick.
Okay, Patrick, go ahead, please.
In the past months, the federal government has observed an increasing number of Australian citizens leaving the country to fight in the Middle East. According to the federal government, there are now about 60 Australians fighting for Islamic radicals in Iraq and Syria. Attorney General George Brandes recently warned that radical Australians fighting abroad constituted the greatest domestic security problem that the country has had to face in many years. This is the government's #1 national security priority, he said in an interview with Sky News. Recently, counter-terrorism officers barred 288 people from leaving the country as part of efforts to control the involvement of Australian citizens in armed conflicts abroad, according to Immigration Minister Peter Dutton. He said that counter-terrorism officers either stopped people from boarding or removed them from planes before they took off. He was concerned that more Australian citizens were looking at fighting abroad. Consequently, the Department of Immigration and Border Protection has had to assess more than 100,000 people who intended to leave the country. Newspaper reports show that at least 10 Australians have so far died in Syria and Iraq, including a 22-year-old Sydney man, Zakaria Rudd, who had appeared in a recruitment video for the Islamic State in Iraq and Levant, ISIS. Prime Minister Tony Abbott declared that the government would crack down on homegrown terrorists and Australians involved in extremist activity. The government that stopped the boats will stop the jihadis, he said.
Okay, hold on. Yep, go on. Patrick, can you finish the last?
Yep, sorry. Yeah, that's right, yep. To address the growing involvement of Australian citizens in armed conflicts, the federal government is considering an amendment to the Australian Citizen Act 2007 Commonwealth in order to allow the revocation of the Australian citizenship of Australian citizens with dual citizenship who are involved in terrorism and armed conflict abroad. In particular, 4 legislative proposals are being considered.
Okay, thank you, Patrick. We'll begin with proposal 1. I'm gonna move to a different share screen now. And then ask Patrick to, oops, the wrong one, sorry. We'll do a share screen of the PowerPoint. And then, so Patrick, can you read proposal 1 for us?
Yes. Under the proposed amendments to the Australian Citizenship Act 2007, the Minister of Immigration and Border Protection shall be authorised to create guidelines as to what constitutes homegrown terrorism.
Okay. Good. Now, the first thing we need to do is to identify the legal issues. Okay. I will not tell you what the legal issues are, but I'd like to hear from you what you think are the legal issues here. You might be able to get a sense of what is the wrong one from the way I make my comments, but as I said, certainly I'm not going to tell you what the legal issues are. So, can I ask you, as a community of learners, and in our community of learners approach, can I get you to tell me or suggest to the rest of the group what you think the legal issues are? I'll give you a minute to do that. After 1 minute, I'd like you to type in the chat box what you think are or is the legal issue involved in proposal 1. Okay, 1 minute. I'm sure you've thought about this, so it should be easy. Please identify the legal issue involved. I will provide some guidance to be sure. Okay, so we will begin. So if you're ready, start typing. I'm just copying from what I see here, okay? Except that I have a problem sometimes copying them because as soon as a new chat comes in, everything just moves. Okay. So what I need you to do is state what you think is the legal issue. Okay, I state the legal issue. So for now, don't provide side comments for now so we don't get confused. What I'm asking you to do for now is just focus on stating what you think is the legal issue. Don't provide any comments for now because it can get confusing. Because I'm trying to copy what's in the chat box. Now remember, as I said, put it in a, it has to be in a sentence, if you could. What else is there? Oops, moved on. Are you able to see the screen if I make it, if I reduce the font size? Can you see it still? Can you read it still? Is that a yes? Okay, that should, good.
Yes, we can.
Okay, that's good. What else? I'm just trying to see what else I've missed here. Okay, I couldn't see the others. I'm having a hard time, but would these be enough for us to work on? How many are these? It's about 9. So we've kind of identified 9 legal issues here. So does the minister have the authority under the Constitution to do this? So that's one. The other one is issue of revoking citizenship through a legislative delegation provided by Parliament to the executive. Another one is it constitutional to delegate power to define terrorism? Fourth, who is taking the action? Does that person have the power? Is the amendment valid? 6, whether Parliament can delegate to the Minister the power to create guidelines. 7, separation of powers between the Minister and the Judiciary. 8, does the Minister have the power to make a guideline under the legislation? 9th, issue of revoking. Okay, it's up there. Okay. Now, so that's a repetition. So we have 8 suggestions of what the legal issue is. Can I get a suggestion on how we should be able to articulate the legal issue for proposal number 1? Can somebody take the floor now? Or you could put it in the chat box, but this time, having seen the contribution of all the other of your peers, what we're trying to do now is for you to articulate what you think is the legal issue or are the legal issues.
Hi, Manjo, it's Catherine speaking.
Catherine, yes.
Hi there. I've got a quick question and then a response to your question, if that's okay.
Yep, go ahead.
So the first question is the proposals that you're actually writing down on the slides now, will they be available on Moodle to have a look at, or do we need to be making notes as well at this time?
I can make them available in Moodle. Yes.
That would be great. Thank you. In terms of looking at the legal issues, does the Minister have the authority under the Constitution to do this? Is the first point that somebody's made there. We'd obviously need to have a quick look at the Constitution, what the Constitution provides for in terms of delegating authority. If there's nothing in there, we'd need to look at the relevant case law that then points in the direction of delegated authority.
Okay, but I need you to articulate what the legal issue is. Frame it as a question. Is it valid, or would it be valid for, so along those lines?
Would it be valid for Parliament to allow the Minister to have delegated authority to create guidelines as to what constitutes homegrown terrorism?
Okay. So, so we have a suggestion here. Would it be valid for Parliament to allow the Minister to have delegated authority to create guidelines? Okay. Any suggestions on how this can be improved? Are we happy with this?
Margie here, Manjo.
Yes, Maggie.
Perhaps a better way of saying it would be, should the Minister have delegated authority to create guidelines?
Should the Minister have delegated authority to create guidelines? Okay. Now, I'm going to make my comments, okay? And remember, as I said, when I make for those who are not saying yet, please mute yourself. So when I make my comments, they are never meant to offend anyone. This is just purely clinical, okay? So for the purpose of us learning something. Now, the problem with this suggestion, would that be fine? So can I just get the, the consent of
course. Of course.
If there's a mistake, I need to point it out without, my purpose is not to embarrass anyone. This is just part of the learning, okay? Otherwise, you'll end up getting confused. So the problem with the second approach is, should the Minister have delegated authority to create guidelines? If you answer yes, he should, so what? Or if you say no, it doesn't. I think, especially in the context of constitutional law, the better way to do this would be to actually always focus on, would it be valid? Or would this be valid? Or would this be constitutional? Would this be unconstitutional? In fact, one approach to do this is looking at this specific proposal, okay? You can ask this question: in what ways can this proposal be invalid? Okay? I mean, to me, this is a shorthand way of identifying the legal issue, okay? What I would do is, I will ask, okay, if this is your proposal, in what case can this proposal be invalid or unconstitutional? Okay? If we approach it that way, and we can do this for all the proposals, tell me. Now, this is what we're going to do now. We're trying to, identify the ways by which this can be valid. So, and then we will try to articulate the legal issue, okay? So let me ask you now, looking at the proposal, in what ways can this proposal be invalid or unconstitutional? I'm just using a different approach now, but we will still end up with the same, with the same end result of coming up with a legal issue. So can I get from you, in what ways can this proposal be invalid or unconstitutional? You can either use the mic or put it in the chat box.
I think it could be invalid if, someone's just typed it out, so never mind.
No, go ahead.
Someone just said, everyone's putting in the chat box that if the minister doesn't have the authority to create those guidelines, it would be invalid.
If minister does not have the authority from Parliament.
The authority under the Constitution, I think that's what we mean. So he's not authorised to make those guidelines, so then it would be invalid.
To me,
sorry, I'm confused having read all these things in the chat box now.
It still doesn't help me. What's the legal issue here? In what ways? If you say that if the minister does not have the authority from Parliament, it's like, I think the fact say that there is an authority from Parliament. What exactly is the problem here?
So is the question then, what authority does the minister have? And does that fall in that authority? Okay.
Try to think back to the notion of the three branches of government and the separation of powers. Okay? Look at that as a principle. Separation of powers. If you look at the principle of separation of powers, what is problematic about this proposal?
The minister is part of the legislature and the cabinet, the executive.
Okay, so what? Okay, Vivian is saying no separation. Okay, Vivian, tell us. What is the implication about there is no separation? What are we saying here? What's the problem with this proposal?
That he's part of the executive and he's now going to be creating a guideline, and that should be what Parliament does.
Wait. Creating a guideline, meaning what? What's a guideline? It's a
law.
Exactly. So what's the problem here? Say it again.
No.
Say it again. What's the problem? Lost it. What was the problem? Somebody talked about subordinate legislation. Oops, sorry. What's going on here? Okay. It's not coming out. What's going on? I can't. Okay. Talk about subordinate legislation. Hey, for the others, can you turn off your mics? I'm hearing a different kind of sound there. It's like heavy breathing. What's going on there? Okay.
Heavy breathing.
I'm hearing deep heavy breathing there. It's getting me distracted. Okay. So somebody told me about subordinate legislation. What's the issue here?
Joe?
Yeah?
Is the answer, does the executive have the power to make subordinate legislation?
Okay, so that's one point there. How come it's not coming out? I'm just going to move it up. Does the minister... What's the point? Can you say that again?
Does the executive have the power to make subordinate legislation? Sorry, I have a cold.
No, I'm not convinced. Are you convinced? Does the executive have the power to make subordinate legislation? My answer would be it depends. What would it depend on?
How about, well, to simplify, would it be, does the executive have the power to make laws? Because their role is to implement.
It doesn't help me as far as this proposal is concerned. Does the power Does the executive have the power to make laws? It doesn't help me. See, can somebody help me here? I'm not good.
It's Vivian. Can you hear me?
Yeah, I could.
Yep. I think the problem would be that you've got the minister who's part of the legislation, and he's also the head of the executive, but he's going to be making the laws and the guidelines of how to implement the laws. So he's got a lot of power there. He only just needs the judiciary on board, and then he'd be able to have full reign.
I'm getting more confused now. I'd like to go back to that question I have. In what ways can this proposal be invalid or unconstitutional? What is the legal issue here?
Can I have a go? Laurie's here.
Okay, hold on. Melissa here is close there. If it offends the separation of powers, we're getting closer. Yes, who said he or she wanted a go? I couldn't hear the person well.
I forgot what I was going to say.
Was it Laurie? Have a go. Go ahead.
Well, I think would it be undemocratic for a minister to have that power? No.
Don't use the word undemocratic. It's not legal. It's
okay.
It's not. It's more of a political science thing, really.
Okay.
Okay. Is it valid for Parliament to? Come on, help me with this. Is it valid for Parliament to? Come on.
Is it valid for Parliament to make laws for the peace and good order of government?
No, that's not it. No, in the context of the proposal, I'm going to just erase this proposal one because it might be confusing. Hold on. There's an overlap of texts here. I'm just going to put this away. Okay, coming from my suggestion there, is it valid for Parliament to what? What's the problem? Is it valid for Parliament to?
Manjo, is it valid for Parliament to delegate lawmaking power from the legislature to the executive?
Okay, now that's too broad.
No.
We're getting there. Too broad. In the context of this proposal, is it valid for Parliament to delegate?
To the minister.
Okay, to the minister, the power to?
Make law.
Yeah, to make law in the form of guidelines. Do you think that's the legal issue?
Well, if it's not, we're going to be in a lot of trouble.
Okay, would it be invalid? Okay, so meaning, if that were the legal issue, what rules do we know? Because so if you look at the proposal, what has actually happened here is that the law created by Parliament authorizes the minister to create guidelines. So the guidelines actually constitute law. So in other words, Parliament has delegated the power to the minister to create what we learned to be called subordinate legislation. So the question is this delegation of lawmaking powers to the minister valid? Is that allowable, knowing that there's such a thing as a separation of powers, knowing that it is for the legislature to pass laws and for the executive to execute laws? Yeah. Number 6. Michelle, it's restating what is in number 6, whether Parliament can delegate to the minister the power to create guidelines. More than that, it's actually the power to create law in the form of guidelines. Because if it's just to create guidelines, it doesn't mean anything. It doesn't connect to certain legal principles. But when you say it as delegating the power to make law. Okay, so if you want even it to be clearer, is it valid for Parliament to delegate to the minister, who is a member of the executive, the power to make law in the form of guidelines? You then begin to see the tension. You begin to see the drama.
Joe, can I just, sorry to interrupt.
Yep.
I disagree slightly, because I think the issue is sufficiently captured in number 6, because then when you go and deal with the law, what is a guideline? That's where you deal with a guideline is a law, and then when you do the application, you do, the connection between what is law, what is guideline, can the minister do that? So I don't think that you necessarily need to spell out what that is in the issue, because that comes down the track. That's the whole point of IRAC.
The problem with guidelines is it means little to us. If you look at it from the viewpoint of constitutional law, what do we mean by a guideline? What's that concept?
Exactly. So the issue is, can a minister create a guideline? And then you look at what the law says and you look at what is a guideline, and that's a part of applying the law. That's not what the issue is, because that's the next stage. What is a guideline? Because you can't be expected to know as a student that a guideline is law or isn't law, or is subordinate legislation. You have to go off and do that specific research, and therefore that becomes part of the body of your answer.
Actually, we did discuss that in the first few weeks. We talked about subordinate legislation under the principle of separation of powers. We talked about.
Yeah, I agree. But if we're talking about, okay, client comes to you, say like in the legal memorandum, when you're restating it back in the IRAC formula, you're saying, okay, this is the question you've asked me. Can a minister create a guideline? And then when I'm responding to that, I'm going to tell you what a guideline is and why it fits into a certain piece of law.
Okay.
Because say the client doesn't know that a guideline is a piece of law, isn't a piece of law.
So how does that help us for you to be able to identify define what a guideline is? How is that helpful?
Well, because you need to know if it is a law or isn't a law, and who has power to do it.
Exactly. That's part one. Is a guideline a law? But is that the legal issue, whether the guideline is in fact the law? Is that the legal issue? Is that it's one
of the issues in there, yeah, but that's not the issue that you're presented with on the face of it. That's a deeper issue within that.
Exactly.
And that's where...
Exactly. There is a deeper issue, which is why I pointed out in that example, look for the underlying problem.
Okay, but we're not doing the IRAC formula where we're first stating the conclusion. We're doing the IRAC formula, so we're starting with
It doesn't really matter. It doesn't matter. In both cases, you need to be able to identify the legal issue. If you say that the legal issue here is whether or not the power to create, whether or not a guideline is a law, I mean, what's that? What's the constitutional principle involved there? What's the problem about whether or not that's valid or not? Is that the problem? Whether is the guideline created by the minister law? Does that constitute law? Okay, so if you say that it constitutes law, on what basis? We're missing a legal principle here, an important constitutional principle. Bring it back to what we were discussing. We were discussing the separation of powers, where the power to legislate belongs to Parliament and the power to execute belongs to the executive. That under the principle of separation of powers, each acts as a check and balance on the other. It's for Parliament to legislate. It's for the executive to execute the laws. It is not for Parliament to execute the laws. It is for the courts, for example, to adjudicate on whether the law is valid or not. None, in theory, none of the other branches is meant to exercise the power of the other, which is why if you look at the Constitution, and even in the absence of a Constitution, if you speak of constitutionalism, there should be these three separate bodies of government. Because if you put all of these all of these bodies together, the power to legislate, the power to execute, and the power to determine whether the power being executed is valid or not. If you put that in a single person, then that becomes despotism. That becomes a tyranny. That becomes a dictatorship. That is the broad constitutional principle we're talking about. So in other words, the point is, what is offensive? What seems to be offensive about the idea of Parliament authorizing the minister to create guidelines? What is offensive with that idea? From the viewpoint of constitutionalism, that leads you to the legal issue. It's not a quibble of, is a guideline a law? If you argue, yes, it's a law, or no, it's not a law, so what? It doesn't. So if you say that it's not a law, how will your argument be like? It's not a law because, why isn't it a law? So my point there is,
I think if it's not a law, it's not infringing on the legislature. So if they're just doing something in the execution of their powers and they're not creating law, then it's not a problem. But if they're being delegated the responsibility to create law, that's where the separation of powers is infringed. And that's what the question is.
Exactly.
So you need to know whether it's a law.
Exactly. You just pointed out. You raised the issue of delegation. You issue about the delegation of lawmaking powers. So the issue is the delegation of lawmaking powers to the executive. It is not whether or not, which is why if you see the example I gave here, the power to make law in the form of guidelines. Because if you were to say the power to make guidelines, it's too vague.
Yeah, but before you said that that it was too broad to say simply that can the executive have lawmaking powers. So someone chimed in and said that it's too broad. And so if we're identifying the legal issue, it's either too narrow that we refer to it as a guideline, or it's too broad that we're talking about the ultimate issue. But I think that both of those things are correct, because it's going to lead you down the path of, when you're in your relevant law and application section, you're going to deal with all of those issues because you have to deal with all of them to answer the question.
That's fine. I mean, convince me. That's fine. I haven't seen the arguments yet. So I'll give you the benefit of the doubt that you would like to restate it. You would like to state the legal issue as whether or not Parliament has the power to delegate to the minister the power to make guidelines. That's fine. I leave it up to you. And I would, I'll read what you write. No problem with that.
Okay, yeah, because I think it makes sense, like, rather than trying to say, take the broad road or take the narrow road, both of them are right and both of them are wrong. I think it doesn't matter what way you go, so long as you do both in the body. Because at some point you're going to state some broad principles and you're going to have to state some narrow principles, and you're going to have to apply those to the facts.
Sure.
So it all comes out in the world.
Yeah, that's fine. I appreciate that. As I said, I'm not here to tell you what the legal issue is. It's for you to determine. All I'm doing is to, get us into the practice of trying to identify the legal issues. So I think we're done with that part. So we'll go to the IRAC part, meaning the rules that may apply. So we've got a proposal here. So the other proposal was, I'm going to copy this. Is it valid to delegate to the minister the power to make guidelines? And we know what those guidelines are, okay? They are guidelines in relation to the proposed legislation, to the homegrown terrorism. Okay, so we have two possibilities here, 1 and 2. So I'm gonna make them 1 and 2 so we can see them. Okay. If we go by the first one, what are the rules or principles that are involved here? That's part of the IRAC format. Are we still there? How many students are left here? Oh, okay. most are still there. So if we go by the first suggested legal issue, is it valid for Parliament to delegate to the Minister the power to make guidelines? What rules or legal principles come to mind that will be helpful in answering that specific legal issue? Okay, one is, what power does Parliament have? Comments? What did Melissa say? Section 51. Ah, you're bringing Section 51. Why should it be Section 51? Is that the relevant rule here? What is Section 51 about?
That's the guidelines for what Parliament. Parliament.
Talk about Section 51. I saw a lot of chat here talking about Section 51. So the question I raised is, why is Section 51 relevant here? Why are we bringing up Section 51?
Well, 51's the section that stipulates the areas where you're allowed to make laws.
Right. Okay. We haven't actually discussed that, have we? We haven't.
No.
There.
No.
Remember, Section 51 relates more to the division of powers between the state and the Commonwealth government. Let me repeat. Section 51 relates to the tension between the Commonwealth and the states. That's where the division of power is between the states and the Commonwealth. Is that relevant here? I mean, it could be, but that shouldn't be the focus here because we haven't gone there yet. But what was the legal principle that seems to be apt to the legal issues here, to either one or two? It's the issue of separation of powers, isn't it? In particular, what? The rules on subordinate legislation. Whether or not it is valid for Parliament to delegate certain lawmaking powers to the executive. Let me repeat. A broad constitutional question that we are confronted in relation to, I think, to proposal one is it valid for Parliament to delegate some or certain of its lawmaking powers to the executive? That is, in fact, a constitutional law principle, isn't it? A constitutional law question that we are often confronted with. And there are cases revolving around that. Because one could argue that's impermissible because under the separation of powers, certainly it should just be Parliament that is able to pass legislation, not the executive. And therefore, for Parliament to delegate lawmaking powers to the executive seems to go against the idea of the separation of powers, which goes against the principle of constitutionalism. Okay? So anyway, are we clear so far what to do? We'll move on to proposal 2 because it's now 7:17. Are we happy with this so far? Well, as I said, my job is not to tell you what the issues are. It was just to help you think through these proposals. Are we happy to proceed? So the warning I had there, the caveat is, do not deal with topics or constitutional themes that pertain to later weeks, which we haven't discussed yet. So do not go into whether or not that Parliament has the power to create legislation relating to homegrown terrorism. Don't get into that. You could, but it won't be helpful because that's not what we're into. Under the power of the Commonwealth Parliament, I am telling you now, if we will go into Section 51, has the power to make laws relating to the defense of the Commonwealth. So that's, within the power of Commonwealth. Don't get into that. We're not, focus on the topics from sections from weeks 1 to week 6. Okay? Just as a warning. So in other words, if something relates to, constitutional rights, don't get into that because we haven't been discussing those yet. We will discuss constitutional rights, I think, in week 11. So don't go into those topics which we haven't discussed. Focus, on the other hand, on constitutional law principles that we have covered so far. So are we happy to proceed to proposal 2? And then we will determine if we call it a day after proposal 2. Are we good? Okay, good. Okay. Yep. So proposal 2. Can somebody read again proposal? Can somebody read proposal 2 for us?
Yep, I can read it, Patrick.
Thank you, Patrick. Go ahead, please.
The Minister of Immigration and Border Protection is authorised to declare an individual as being involved in homegrown terrorism and revoke his Australian citizenship if he possesses dual citizenship.
Thank you, Patrick. Thank you. Okay. I'll give you 30 seconds or a minute to think about this. What do you think is the legal issue? Again, in doing so, ask yourself the question, in what ways might this proposal be invalid or unconstitutional? Okay? Because that will help you identify what the legal issue is. Okay, so if when you're ready, please type in the chat box what you think is the legal issue. So in other words, what's the underlying problem really of this proposal? Can the minister? Okay, so we're beginning to get some here, and I'm just gonna slowly transfer them to the screen. Aha, from Forbes. Okay. Good. Oops. Can the minister revoke citizenship? Okay. Any more? Any more? Oh, wait. There was something crucial. Okay. Okay, Jerry was already making an argument there. Okay, good. So some of you are hitting on the nail. So you're getting it right. So you're getting it right. Some are. Okay, am I missing anything here? Yep, okay. Okay, are we happy with that? Create judicial power. Okay, hold on, here we go. So these are some of the legal issues you've identified. With numbers. Okay, we've got about 8. Oh, not number 1 though. So. Okay, so let's look at 1, 2, 3, 4, 5, 6, 7. What are some commonalities here? Then we just put them together. Does the executive infringe on the SOP by making final determinate decisions usually served by the judiciary? So what's that? That's related to executive making a judicial decision. Okay, they're the same, right? So, what seems to be the legal issue here? The common theme that I'm appearing to that seems to be apparent to me, that's emerging. It seems to be about the infringing on the judiciary. That's a common theme there. Making a judicial decision. Okay. So the issue is not citizenship, but the minister using aha from Amanda. So, okay. There's a question here from Amanda. The issue is not citizenship, but the minister using judicial decisions. What do you think? Comments?
Can I just clarify that?
Go ahead.
It was just more of a light bulb moment for me, because when I had been looking at this previously, I kept looking at this from a citizenship point of view. Does he have the power or the right to revoke citizenship? But now I see it as not a citizenship issue. It's a, does he have the right to make a judicial decision, whether that be about citizenship or anything else. So that was more of a light bulb statement.
Okay, thank you, thank you. So that's good. Thank you, Amanda. That was helpful. Yeah, you're right. So what do you think? This doesn't seem to be a citizenship issue, is it? Because, you know, it's something that we're not meant to be discussing yet. It has something to do, again, with the separation of powers. What's the problem here? What exactly is the problem here? Tell me, what's the problem? Please write in the chat box. What's the problem with this proposal? So Anthony says it's about the minister being the judge. Why, Anthony? It makes sense. It's about, for this proposal, it's about making the laws, or is it about judging? Is that the problem? So it's about the executive performing a judicial role. What is a judicial role? Yeah, okay, go on. So what do you mean by the executive performing a judicial role? So what is the legal issue here? You're getting, I think, are you getting the sense now of what you're meant to do? Can somebody tell me, how would you formulate here or articulate or state the legal issue? What is the legal issue? You know, having had this discussion now, what is the legal issue? Can I get some comments there? Can we help each other now? So what is the legal issue here? It can be a two-step process if you like.
Is one of the issues?
Yep.
Is the fact or the revoking of Australian citizenship? The revoking of Australian citizenship, is that a judicial function?
Okay.
Firstly,
stop. Is that Michael?
Yes.
Okay, thank you, Michael. Hold on. I'm just going to write that down. So is the act, is the minister, I'm just going to, so is the Minister's Act of revoking Australian citizenship tantamount to, was it exercising judicial powers?
Yes, that's correct.
Okay, hold on, it's not appearing. Just going to move it a bit. Okay, if so, if it is, would that be valid?
That would be the next question, wouldn't it? Yeah.
Huh?
That would be the next logical.
Yeah. Okay.
Progression of the.
Okay. What do the others think? Are you happy with that? Yes or no? Can you just say yes or no in the chat box, just for us to see? Happy with that? Yes or no? Can everybody say yes or no, please, on the chat box? Just so we get a feel. Okay. Now, can somebody explain to me, why is that the correct? You seem to be generally in agreement that that's the correct legal issue. Okay, tell me, why is there some kind of a consensus or even a unanimity that that is the correct legal issue? Why is that the correct legal issue? Can somebody just explain to the rest of us why you think that those two are the legal issues for this proposal? Can somebody take the floor? Come on.
Can I?
Who was that?
It's Vivian.
Vivian, yes.
I'm just actually in transit at the moment. So can I put in, is it to do with the fact that the minister is now making a decision? He's doing the investigation and making the decision, which is kind of like a binding sort of decision that he's trying to do.
Okay. And so the exercise of a power to make a binding decision by the minister, is that problematic from a constitutionalism point of view? Is it problematic? If
And
yes,
also he's got a chapter 3 court.
why is that problematic? Can somebody tell me?
Well, it may or may not be problematic. It would have to be determined on research on what is a judicial, the definition of a judicial decision.
Okay.
Because a minister can make decisions on certain things, and they should be able to make decisions on certain things. But
hold on. Yours. You're saying that the question here is the minister making a judicial decision? Is that a question?
No, it is. It's the question is the minister, the act of revoking citizenship, is that decision making process, is that
Sorry, I'm missing something. Sorry.
Is it a judicial?
Yeah.
Is that a judicial decision, or is that a ministerial decision, or some other?
Sorry, I missed that.
A judicial, yeah. I guess they're the good words. Judicial powers. Are they judicial powers?
Yeah. So would that be right? Is the minister's act of revoking Australian citizenship tantamount to exercising judicial power, or does it amount to exercising a judicial power? If it is, would that be valid? So those are two corollary questions. And Michelle is making the argument only judges can exercise the power to make judicial decisions. Interesting. Will lose access to natural justice, Michelle? I would avoid that. That's not appropriate for this discussion. I would suggest you focus on the separation of powers here. You need to do research where would there be instances when the minister, for example, is given authority to kind of exercise judicial powers or quasi-judicial powers, and would that exercise be valid? So, okay. Any questions, comments so far? So you know what the rules are applicable. You know what the applicable rules are, right? In other words, the moment you have identified the legal issue clearly, you then see it's so easy to know what the legal principles are that relate to it. And having identified those legal rules or legal principles, you then apply those legal rules or principles to the facts and to the legal issue for you to arrive at a conclusion. So in other words, your conclusion then is supported by clear evidence. Your conclusion is supported by the legal rules and principles that shed light on a resolution of the legal issues. And as somebody suggested, the IRAC format, in fact, when you come up, and I think I put it in the forum already. So both for IRAC and IRAC, the IRAC is there, but usually when you come up with an answer, even in the legal memorandum, it will be best if you make an initial statement, if you could, that the proposal is invalid, and these are the reasons. And then that's when you begin. So in other words, you state outright from the start what your conclusion already is, and then you start discussing it. And that's when you begin, the proposal is invalid because it violates blah, blah, blah. Now, the legal issue that the proposal raises is this, and these are the rules. Now, if you apply these rules to the specific facts, it is apparent that, so you see the logic and the beauty of using the IRAC format. Okay. Do you want to go on? Or are we done? What time is it? 7:30. Go on. Really? Okay. Can we end at proposal 3, or do we have to go to proposal 4? That might be too much. I'm not sure if I'm giving away the answers. Am I? Go to 4. Okay. No. I don't think I want to discuss proposal 4, mainly because it's a Friday as well. So it might be too much. let's just go to proposal 3 and then we'll call it a night, because for some of you, you might have to go on dates. Okay, let's look at proposal 4. Patrick, are you still there? Patrick?
Yeah, absolutely.
Oh, can you read proposal 4 for, sorry. Proposal 3 rather. Patrick, can you read proposal 3 for us, please?
I can do that. A newly established special federal terrorism court shall be created, whose judges shall have the power to investigate allegations of homegrown terrorism against any Australian citizenship with dual citizenship, and to revoke his or her Australian citizenship if his or her involvement in homegrown terrorism is established.
Okay, thank you. I made a mistake there. That should be Australian citizen. Okay, sorry. No, that one. So, thank you. So, a newly established special federal terrorism court shall be created, whose judges shall have the power to investigate allegations of homegrown terrorism against any Australian citizen with dual citizenship, and to revoke his or her Australian citizenship if his or her involvement in homegrown terrorism is established. Okay, let's give it 30 seconds. And when you're ready, please post in the, where do we begin? Do we begin by identifying the legal issue, or do we begin by going back to the suggestion I had in proposal 2, where what you first do is, in what ways might the proposal be invalid? So we could begin with that, or you can just identify the legal issue. So, but I think it's always helpful to me in constitutional law, if you see a proposal like this, you ask the question, why might this proposal be invalid or unconstitutional? What seems to be wrong with this? Or is this actually okay? So some have began to come up with a problematic issues. Can judges undertake non-judicial activities? Okay, hold on, wait. Is this allowed for Chapter 11 court? Okay. Okay. Anything else? Try not to comment yet on your on the chats. Just for now. So that's in what ways it could be invalid. Okay, I see the point of Amanda. So it could be, in what ways it could be invalid. Yep. Mm-hmm. Would this constitution be what? What's that? Sorry, I couldn't read it. Would this constitution be constitutionally valid? Michael, what's that? Michael.
I don't know what happened there. Will this tribunal?
You better start
getting
people there, Michael. I would understand. I'm getting too. Anything else?
It's been a long day.
I know, Michael. It's a Friday. Anything else? Okay. Are you happy with that? We're missing something there. Okay. I mean, we've kind of identified the legal issue has been identified, but it's missing a step. This seems to, so remember, for proposal 1, we kind of, was easy to identify the legal issue. For proposal 2, we kind of went through a 2-step process, right? Where was that? No, proposal 2, 2-step process. So this was step 1. The Minister's Act of revoking Australian citizenship. No, it's not writing. So step 1 is the Minister's Act of revoking Australian citizenship tantamount to exercising judicial power? Step 2, if it is, will that be valid? Okay. So for proposal 3, some of you have hit on the head what the legal issue seems to be, but it's missing a step. Hold on. Okay. From Eliza, does the Parliament have the power to create a new court? The answer is yes. It's under section 77 of the Commonwealth Constitution. So Section 77 of the Constitution authorizes Parliament, the Commonwealth Parliament, to create federal courts. Okay, that's not the issue, I think. I wouldn't think that because we haven't gone into it at any rate. Okay, okay, so there's a question. Okay, are we happy with that? We have a number of kind of legal issues here, but hold on, where was that of Amanda's? Disappeared. I might have erased it. Why is this non-judicial though? Hold on, what's that? From Jane, why is this non-judicial? Ah, okay. So Jane is asking, why is... No. I think Jane was asking, why would these acts constitute the exercise of non-judicial functions? So that's what she meant. Why do these constitute the exercise of non-judicial functions? I think that's what Jane is saying.
Yes.
Right, okay.
Yes, sorry, I'm not sure if you can hear me. My microphone's been playing up.
I could hear you.
But
So
somebody asked if judges can undertake non-judicial activities, but I'm just confused. Why would creating a court with judges in it be non-judicial? Wouldn't that be judicial?
Okay. So,
or am I missing something?
Yeah, you are missing something. So let's assume there's a court, remember, let's be clear, we're talking of the federal level, okay? We're not talking of state courts here. We're talking of a federal court. The rules are different at the state level. And I will not digress into that because it might confuse you. We've discussed it before. At the federal level, let's assume that there is a law which creates a court. And the court obviously is composed of judges. They're federal judges. The question is, what if that court has the power to investigate offenses? Or has the power to create reports on whether the executive is performing its function well? Okay, those functions, are they judicial? Are they legislative? Are they executive functions? Or what if there is a law which says that these judges have the power to create a law that defines what state terrorism is? Is that exercise, are those activities, are those acts, do those acts involve the exercise of judicial power or legislative power or executive power? So you see what I mean?
Manjo?
Yes.
Is there a separation of powers issue with the judges investigating and possibly performing their judicial function?
Wait, hold on. That, in fact, I think is the crux of the matter. Are they performing judicial functions in doing that?
You understand, like the police can't, there's always that separation of the powers between the police and the judiciary.
Wait. Don't confuse the state courts and the police and the federal courts and the federal police. Okay? Do I digress into, we've discussed this, but do you want me to digress into a discussion of separation of powers between, the difference between at the level of the Commonwealth and at the level of the states? Or not? I don't want to digress.
No.
What exactly is the problem here? What's the problem here? What are they doing? These are judges. What are the judges meant to be doing? Are they exercising judicial? So, okay.
They're meant to only exercise judicial powers.
Looking at the proposal, my question is, are the judges performing a judicial function? Are they performing an executive function? Or are they performing a legislative function? I think we need to settle that, right? Okay, so that I think is the first thing that we need to settle. So you might ask the question, in doing these things, are the judges performing a judicial function or not? If they're performing a judicial function, we don't have a problem. If they are performing a non-judicial function, do we have a problem? What non-judicial function might they be performing? Do you see what I'm getting at? So some are saying performing executive functions. Why? Why would you say they're performing executive functions? You have to do the research. But are you getting something from, from this? You know what I mean? From Michelle, because there isn't an actual controversy. So what, Michelle? If there is no actual controversy, what's the point there? Tell us, can you enlighten everyone here? So if there is no actual controversy because you're investigating, what does it mean? Michelle, can you explain? Michelle? Okay, Michelle said the judiciary, okay, so Michelle is saying the judiciary does not have jurisdiction unless it involves an actual controversy. And Michelle seems to be suggesting that an investigation does not involve an actual controversy, therefore, it involves the exercise of non-judicial functions. Is that the argument, Michelle? Michelle, is that the argument you're making? Yes, okay, thank you. Okay, so do you have a sense of what the issue here is? I'm not going to write it for you. I think we've discussed it enough. Okay. Can we call it a night? Fair enough. Now, I don't want to go to question 4. Might be too much.
Can I just throw something in from left field here, Manjo?
Yeah, go ahead.
What's the difference between this situation and a judge, say, running a royal commission?
Good question. Is it okay for me to discuss that?
I don't want to take up your time, but...
Okay, yep. So what I'm going to do is to state the legal principle, okay, the constitutional law principle. So, but let me begin by backtracking a bit of a digression, just for us to see the context, okay, because it's more of a way of synthesizing what we know. So, if you follow constitutionalism, we don't want to see a single body or a single person exercising the 3 powers of a government: the power to legislate, the power to execute the law, and the power to determine whether the law is valid or not, because that would be a tyranny. Imagine somebody able to pass a law, execute the law, and he says that execution of the law is valid or that law is valid. That would be a dictatorship. That's a tyranny. We don't want that. Now, however, even if there's such a thing as a separation of powers under the broad notion of constitutionalism, or which is the bedrock of a true democracy, in a parliamentary system of government, there is no real separation of powers. What you have is a partial separation of powers, because when you look at it in a Westminster system of government, the members of the cabinet and the prime minister actually form part of parliament. So because of the fusion of the executive and parliament, there is no separation of powers, clearly, between the executive and the legislature, which is, and you will see the arguments, you will see the statements of the courts that because of the fusion of, in a Westminster parliamentary system of government, the fusion of executive and lawmaking powers, what's wrong with, what's wrong with parliament delegating some of its authority to the executive, when the executive is part of parliament anyway? Okay. Now, however, because of the problem in a Westminster parliamentary system of kind of a fusion or a lack of a separation, we're talking of the federal level, not the state, okay? We're talking of the Commonwealth level here, or the federal level. Because of the lack of separation between the executive and the legislature in a Westminster parliamentary system, in Australia, the High Court has been very clear, has been very vigilant in guarding against any encroachment into the judiciary. So there are two concepts there that are crucial. One is the judiciary will not tolerate either the legislature or the executive performing judicial functions. Let me repeat that. Because of the partial separation of powers in a Westminster system, in a Westminster parliamentary system of government, the High Court has been very clear and has been very vigilant in saying that it will not tolerate either the executive or the legislature performing some judicial functions or encroaching into judicial functions. It will not allow that because, you know, it's bad enough, and I'm not saying it's bad, but, you know, given the fact of a partial separation, if you allow the executive or the legislature to exercise judicial powers, that really is bad. So that's one. The second aspect really is that although the other aspect, therefore, is because of judicial power, because of the separation of power, because of the partial separation of powers in a Westminster parliamentary system of government, the judiciary also will not allow any of its members to exercise non-judicial functions. So the corollary to the initial rule is that because of the partial separation of powers, the members of the judiciary are not, or the courts, federal courts are not permitted to undertake non-judicial functions. So the courts cannot perform executive functions. The courts cannot perform legislative functions. Clear enough? Now, the other thing is, if we hear about if you look at the Dignam's case, you will have situations where some judges actually exercise executive functions. And I will go back to the Royal Commission in a short while, okay? But the High Court has recognized that there are instances when a member of the federal judiciary may actually be performing certain executive functions. The High Court will tolerate that, will allow that, for as long as one, it is with the consent of the member of the federal judiciary, and two, that the exercise of executive functions by the member of the federal judiciary is compatible with his office as a judge. In other words, you can question its compatibility if it brings into, if the exercise of those functions brings into disrepute the independence of the judiciary, or makes the judge a functionary or a tool or an instrument of the executive. Because if that were the case, that would be incompatible with the independence of the judiciary. Okay, so let me repeat. Although as a rule, the High Court will not tolerate federal courts to exercise legislative or executive functions, under the principle of persona designata, the High Court has said that it is permissible for a member of the federal court or a federal judge to exercise executive functions for as long as one, it is with his consent, and two, the exercise of those executive functions are not incompatible with his functions as a federal judge. So clear enough? Those are the principles. Now, going back, if, for example, the High Court there have been cases where a member of the judiciary was asked to make a report on behalf of the executive, but part of the conditions was that that report will only be published if the executive is in agreement with it. The High Court struck down that piece of legislation because it felt that the role of the judge in exercising non-judicial functions, meaning an executive function, was incompatible with his office. So, but it goes back to that question: why is it not a judicial function? Okay, so that's a crucial point. When do we know that the exercise of a function by a judge is judicial, executive, or legislature? Let's begin with a statement by the High Court in saying that there are only three powers of government: legislative, executive, or judicial. So if it is not legislative, if it is not executive, therefore it has to be judicial. It also means that if it is not judicial, it is not legislative, it has to be executive. So we go back to that question. What exactly is an executive function? When is the exercise of a judicial function or judicial power triggered? It is triggered only in case of an actual controversy. Okay? So judicial power is triggered only when there's an actual controversy involving rights or freedoms or liberties or the imposition of a liability or the violation of a duty that involves actual parties. Only then can the judicial function be triggered. In other words, if you ask the federal judiciary to provide an advisory opinion or to provide a theoretical opinion, there's a problem between the executive and the legislature, we'd like you to tell us, is this okay to do? We were thinking of passing this law. These are the proposals. Can we give it to the High Court or to the Federal Court of Australia and ask them, do you think this will pass muster and will this be valid? That is asking for a theoretical opinion, for a hypothetical opinion, because there is no actual controversy. In that case, because there is no actual controversy, for the High Court to do that or for the Federal Court to do that would be to exercise non-judicial functions. And as I said, that is not permissible. Okay? So, judicial power. So, Manjo, what question are you answering? I'm answering a lot of questions. I did not answer a question yet. I was just providing you the background information, kind of a summary of what constitutional principles are. I wasn't providing a backgrounder yet, providing a summary. So just in case, you got tired of reading the law or you got confused by the book you were reading, I'm providing a summary, a shortcut of the key principles that are crucial to answering the legal memorandum proposals. Okay, so going back to the Royal Commission, why would it be possible for a member of the judiciary to be part of a Royal Commission? Now, the first question, therefore, in that case is, if you go through the IRAC format, is the membership of a federal judge in a Royal Commission and the preparation of a report, does that amount to the exercise of a judicial power, a legislative power, or an executive power? That would be the first question, right? Then you would say, is there an actual controversy? No. So therefore, he's not creating a law. It has to be executive, correct? So the question is, would it be permissible for a federal member of for a federal judge to be part of a Royal Commission that creates a report for the Commonwealth, and that act of preparing a report is actually an executive function? Is that permissible? And then we go back to the principle of persona designata. For as long as it is with the consent of the federal judge and the performance of such function is not compatible with his office as a member of the federal judiciary, then that's valid. It's Dignan's case or Grollo versus Palmer. Okay, so those would be the cases that you would want to look at. Okay, so that's the answer to the question of the Royal Commission. Yes, because of persona designata. Clear enough? It's 8 o'clock, almost 8 o'clock. Shall we call it a day?
Manjo, could I ask a question just about, I guess, the relationship between Proposal 3 and Proposal 4?
Sorry. Before I go to you, Michelle, I'm not familiar with all the slang in Australia. Clear as mud. Is that good or bad? Huh? What does it mean? It's bad. Okay, Michelle, yes. It's my kids were saying it's so bad. My kids were saying at one point, it's so bad that it's good.
No, that's not what they're saying.
Okay. Michelle, yeah.
So obviously, Proposal 3 versus Proposal 4. Proposal 4 is about a tribunal. So I understand where the constitutional elements come from regarding a court, but where do they come from regarding a tribunal?
Did we discuss this? We're about to discuss. We're, I think, discussing that next week.
Okay, all right, no worries. I'll wait till then.
Well, at any rate, put it this way. The tribunals, which are non-federal courts, okay, the question is, are tribunals exercising judicial functions? That's the point. So if you have an administrative tribunal or a non-federal court, when they make decisions, the question is, are they making decisions that encroach on judicial powers, or are they exercising judicial powers? That's a constitutional law question. Are these administrative or executive tribunals exercising judicial functions or not? That's the key question. If the answer is yes, it's unconstitutional. If the answer is no, then it is constitutional. So in other words, what exactly is it that the administrative tribunal performing? Is it actually dealing with an actual controversy between persons? If it is, it's invalid. But if it is not dealing with an actual controversy between parties, in other words, somebody goes to the Administrative Appeals Tribunal complaining that the Minister of Education, for example, was unwilling to release reports pertaining to an investigation of drug use in certain schools. Okay, is that an actual controversy? No. So in that case, if the role of the administrative tribunal is to determine whether or not the minister had the power to refuse to release that report that is being sought by an individual, did that involve the exercise of, did that involve an actual controversy? If it did not, then it does not involve the exercise of judicial powers. So the reason why it is valid for administrative tribunals, the reason why administrative tribunals are judicially recognized as valid, it is because those administrative tribunals are recognized as not performing judicial functions. They are performing non-judicial functions because they are not dealing with actual controversies. Remember, we're talking of the level of the federal government, of the Commonwealth, not the states. Okay? Because in the states, there is no such thing as separation of powers. So you can have a fusion. You can have state judges performing executive functions, and that will be tolerated at the state level, unless. But again, I'm digressing, so I don't want to get into that. Okay, are we happy with that? Okay, so we could call it a night. Okay, so have fun. Have a great weekend, and I'll catch up with you on Monday. Okay? So good night, everyone. Bye-bye.